Hello, everybody, and welcome to the fourth session of Prime Time Virtual Events, brought to you by P.R.I.M.E Finance. This session is being recorded and will be distributed later. If you continue to participate, you'll be taken to have consented to such recording. You are currently muted and the panel cannot see you. If you have a question or comment, whether for the panel or of a technical nature, please use the Q&A function to get in touch. It can be helpful to us if you include your name and affiliation. Assuming I can work the Q&A function, questions for the panel will be asked and answered at the end of the session. We'll use the chat box to send you messages during the course of this session. Thank you to Lexis and MLEX for their support of Prime Time and their assistance with promotion. Thank you to Dwa Financial Technologies for their sponsorship of all of the first series of Prime Time, and to 3 Hair Court for their sponsorship of this particular event. The topic of the event is the Corporate Finance and Governance Act 2020. It's a recent piece of legislation that makes permanent and temporary amendments to UK insolvency and restructuring laws. Some of these amendments have been contemplated for a long time, and some are a rapid response to the financial crisis emerging in the wake of COVID-19. In essence, the measures aim to preserve corporate value. The most notable changes introduced by the Act relate to, first, a new standalone moratorium or payment holiday on the company's debts. Second, a new restructuring plan, which is very similar to UK schemes of arrangement, but with the added benefit of a cross-class cram down. Try saying that when you've had a glass of whiskey, which I haven't. Third, a prohibition on the enforcement of ipso facto termination clauses. And fourth, exceptions from certain of the foregoing measures that I just mentioned for certain excluded entities and contracts, safe harbors which benefit principally financial counterparties. These measures have been the subject of comment by the Financial Markets Law Committee, of which I am Chief Executive, and I believe during the proceedings you will see a link to that letter in your chat boxes. Now I am going to introduce the panel. We're very lucky to have with us today 2 preeminent insolvency experts to discuss the Act. Jennifer Marshall is a partner in the Global Restructuring Group of Allen Overy. She's chair of the CLLS Insolvency Subcommittee and a former president of the Insolvency Lawyers Association. Jennifer is a general editor of Sweet and Maxwell's loose leaf publication on cross-border insolvency and a contributor to Lightman and Moss, the Law of Administrators and Receivers of Companies. She also contributes to Moss, Fletcher and Isaacs on the EU regulation on insolvency proceedings. Philip Wood is the former head of Allen Overy's Global Law Intelligence Unit and serves as Special Global Counsel with the firm. He's also York Distinguished Visiting Fellow at the University of Cambridge and a former visiting professor in international financial law at the University of Oxford, as well as former visiting professor at Queen Mary University, London. Philip is the author of 9 volumes in the Law and Practice of International Finance series published last year. And so, without more ado, I will now hand over to Jennifer to begin her presentation.
Thank you very much, Joanna, and welcome to everyone to this webinar. Some people have described this legislation as the most significant change to UK insolvency law in a generation. And from my perspective, that is no exaggeration. You could say that these changes are the most fundamental changes to happen to UK insolvency law since 2003, where we abolished the ability to appoint a receiver over all of the assets. I think they are even more far-reaching than that, and I would say that they are probably the most fundamental changes that we've had since our 1986 Act came into force. Now, as Joanna mentioned, the changes in the legislation are not new. They are based on consultations that go back to 2016. Having said that, the UK government was having real trouble finding space in the legislative timetable to get its changes through. And it wasn't until the COVID crisis happened that they were given the opportunity to do just that. And at the end of the day, some of these changes were rushed through with quite some speed. The legislation was introduced into the UK Parliament on the 20th of May, and it was enacted on the 25th of June. Well, when you consider that there are 248 pages of detailed insolvency legislation, getting that through in 1 month was quite some feat. Now, as Joanna mentioned, there are some temporary provisions in the legislation to deal with the COVID crisis. For example, the relaxation of our wrongful trading laws and restrictions on the ability to present winding up petitions, which will last until the 30th of September. And that is similar to changes we are seeing in relation to COVID across Europe. For example, Germany has disapplied the very strict 21-day filing rule as a result of the COVID crisis. But some of the changes in the legislation are permanent in nature, and it's those changes that we really want to pick out and talk about today. So I'm going to talk about two of the permanent changes, the standalone moratorium on creditor action and the restructuring plan that Joanna just mentioned in her introduction. And then Philip is going to talk about the ipso facto provisions, which I personally describe as being a bit like Marmite. You either love them or you hate them. I'm afraid, as a strong believer in freedom of contract, I fall into the hate camp, but I'll let you make up your own mind when you've heard what Philip has to say about those provisions. Just by way of introductory comment before I turn to the detail, it's worth saying that 248 pages of detailed legislation in a month was quite some feat, and it is likely that there may be the odd nit or two in the legislation that will need to be ironed out and resolved in due course. The Act does contain what we lawyers like to refer to as Henry VIII powers, named after the famous monarch of that name, i.e. the power to amend the legislation by secondary legislation so that you don't have to go through the parliamentary process all over again. It's fair to say that there is a lot of debate about such powers and whether they are constitutional or not. And that debate continued as the legislation went through the House of Lords. But there are still some limited Henry VIII powers. So if some of the provisions do not work in practice as they should do, then there is the power to change the law. So starting with the moratorium, what is it? Is it likely to be used in practice? And what difference will it make to the UK insolvency law framework? Well, it's worth saying that we have had a moratorium for small companies for putting together a company voluntary arrangement for some time now. But in practice, that small company moratorium was just very, very rarely used. So the idea behind the new moratorium is that this will now be available to a much wider group of companies. In fact, all companies except certain types of excluded companies that are subject to their own special insolvency regime, such as banks, insurance companies, or securitization companies. And it's very much intended to give the company a breathing space from creditor action whilst it puts together a rescue. Now, many of the attendees on this line might be familiar with the UK administration process, which has a similar moratorium on creditor action.
We seem to have lost Jenny.
I hope I am back.
You're back. That's fantastic.
Apologies for that. I lost it just for a second. Hopefully it will be as quick to get back on if it happens again. So I was saying that the moratorium that arises in this new process is very similar to the stay on creditor action that we have in our existing administration process. The idea behind the moratorium, though, is that it is what we call a debtor in possession process. So the directors will stay in control during the moratorium process, but under the supervision of a monitor who is a licensed insolvency practitioner and who will have a role in supervising the moratorium process. But it will be the directors who take the day-to-day management decisions regarding the company. Now, what types of company can use the moratorium? Well, as I said, any company that's not a special company, that's not excluded, and it doesn't have to be an English company. So, for example, if it is an English company, then the moratorium can be obtained simply by filing documents with the court. However, a foreign company can also use the moratorium if there is a sufficient connection with the UK. And that could include, for example, having English law governed documents. So there's already been quite some debate about whether bond issuers and certain other SPVs who are actually incorporated in an offshore tax jurisdiction, for example, could use the moratorium process. The directors will commence the moratorium if, in their view, the company is unable to pay its debts. But the monitor has to also be of the view that the company is capable of being rescued. So there's quite a fine line there between a company that is unable to pay its debts, but where a rescue is possible, for example, as the result of putting together a company voluntary arrangement. The moratorium process will last for an initial 20 business day period, but it can be extended very readily simply by filing documents with the court for another 20 business days. And if the company needs even more time than that to put together its proposals for a rescue, then it can be extended further, either with creditor consent for up to a year or with permission of the court. And that appears to be unlimited in terms of duration. So it's not yet clear how long a typical moratorium will last. So what's the effect of the moratorium? Well, I think there are two main effects. The first is the stay on creditor action that I've just mentioned, just like the English administration. So, for example, there can be no commencement or continuation of legal proceedings whilst the company is in the moratorium. There can be no commencement of other types of insolvency proceeding, and no steps can be taken to enforce security unless you have the magical financial collateral that the financial markets are so keen to obtain. And no steps can be taken to repossess under a lease. So people who are familiar with the UK administration process will be very familiar with that type of stay. But in addition, the company will have a payment holiday from having to pay certain debts. And those are either debts that arose prior to the moratorium period, or debts which fall due during the moratorium, but under contracts that were entered into prior to the moratorium. So this is what the moratorium is all about. It's about trying to give the company a payment holiday for anything apart from debts that actually fall due during the moratorium and under contracts entered into post the moratorium. Now that is subject to some very important exceptions. And I think the exceptions here are probably more important than the rule itself. So, for example, rent incurred during the moratorium or supplies made during the moratorium have to be paid even if they are under a pre-existing contract. Wages under contracts of employment have to be paid during the moratorium, which obviously makes huge amounts of sense. But there is also a very extensive list of financial contracts which are excluded from the payment holiday provisions. And those are set out in a schedule to the new legislation. And that includes things like loan agreements, derivative transactions, and bonds. So in relation to those types of financial contract, the company will have to continue paying those debts, regardless of the fact that the contract was entered into prior to the moratorium process. And in my mind, that's the crucial point as to whether this moratorium is going to be used in practice. because it is quite clear to me that you can only use this moratorium if you've got the financial creditors on board. Now, if either they've agreed to a contractual standstill of their debts during the moratorium process, or if the company has sufficient monies to continue paying its debt during the moratorium process. When Philip comes to talk about ipso facto provisions, you will see that those types of creditors are able to accelerate their debt during the moratorium process, and therefore the full amount of that indebtedness would have to be paid. So what happens if the company doesn't pay the debts that are excluded from the payment holiday? Well, there are two consequences of that. The first is that the monitor is required to bring the moratorium to an end if the company is not doing what it should do and is not paying the debts that are excluded from the payment holiday. And the second consequence is that debts that are not subject to the payment holiday will need to be paid as an expense, i.e. a priority claim, in a subsequent liquidation or administration of the company if that takes place within 12 weeks of the moratorium coming to an end. And just as an aside, those creditors are also given a blocking stake if the company tries to do a company voluntary arrangement scheme or restructuring plan within that period. Now, whilst the Act was going through Parliament, I think people pointed out that given that the financial creditors are allowed to accelerate their debt, and given that the full amount of the accelerated debt would be excluded from the payment holiday, that inadvertently those provisions suddenly gave priority to the full amount of the accelerated debt, even if that had unsecured status as drafted. And that was clearly an error. That was clearly never the intention. And so I'm pleased to say that an amendment was made while the legislation was going through Parliament to make clear that if a financial contract is accelerated, then the accelerated amount of that debt will not have super priority in a liquidation or an administration. So just to be very clear on that, it is still possible to accelerate, but you don't get super priority status if you do so. And I think that was exactly the right place for the legislation to have ended up. So much for the moratorium. What about the restructuring plan? Well, this is where, as a restructuring practitioner, I get very excited because I really do think that this is a very useful tool in the restructuring toolbox. And again, this is not a new change. It's been in the consultation since 2016, and it's very much in keeping with the European developments, such as the restructuring directive. And even though, as a result of Brexit, we will not need to implement that directive, it was very important to the UK that we remained competitive and that we had restructuring tools that would compete with, for example, the Dutch scheme of the new Dutch scheme, which I understand is going to be implemented very shortly. So what is the restructuring tool and why is it, do I get so excited about it? Well, the new restructuring plan is introduced as a new Part 26A of the Companies Act, which has the heading Arrangements and Reconstructions for Companies in Financial Difficulty. But that's a bit of a mouthful. So we just call it the restructuring plan, or for reasons that you might understand in just a minute, the super scheme. And it's similar in many, many ways to the existing scheme of arrangement under Part 26 of the Companies Act. In fact, it looks like a lot of the text is just copied and pasted from Part 26. But there is one very important new feature, and that is the cross-class cram down, which, as Joanna says, is a bit of a mouthful and not something you would want to say under the influence. And I'll explain exactly what that is in just a minute. But perhaps for some of our international attendees, it's worth just saying a few words about the scheme of arrangements so that we can compare and contrast what the restructuring plan actually is. So I'm sure that most people will know that the scheme of arrangement is an immensely powerful restructuring tool that can be used for anything from extending the maturity dates of financial contracts to a full balance sheet restructuring. And in fact, some would say that it's the UK's greatest export because we've used the scheme in relation to large numbers of cases involving foreign companies, but where the underlying debt is governed by English law. And with a scheme, just like with the new restructuring plan, creditors get divided into classes depending on their rights and interests, both pre and post the restructuring. But for a scheme of arrangement, you need the consent of each and every class of creditors. So you can't get the scheme through if a single class of creditors dissents. Now, restructuring professionals have used other tools to get around this. So, for example, you might put the company into administration and then sell the shares in the subsidiaries to a new company owned by the in-the-money creditors, and then use the scheme to allocate the equity in that company. But it's been quite frustrating that up to now we haven't had a process where you can do the full restructuring through a single process rather than having to use those techniques. And of course, in a Chapter 11, you can cram down dissenting classes. And so that is the main change that has been introduced by the new Part 26A. There is the ability to cram down one or more dissenting classes so long as two conditions are met. The first condition is that the restructuring plan must be approved by at least one class of creditors that has an economic interest in the company in the event of the so-called relevant alternative. Now, it's worth just pausing there to say what on earth is the relevant alternative. And for those who are familiar with schemes of arrangement, the relevant alternative is very similar to the comparator that you would have in a scheme. In other words, it's the process that the company would go into if you can't get your scheme or your restructuring plan through. And quite often, that will be an insolvency process, liquidation or administration. So the first condition is met if you have at least one class of approving creditors who would still have an economic interest in the company in the event that it goes into such an insolvency process. That's quite an easy test to make out, I would say. The second condition, which is perhaps the more interesting one, is that the dissenting class of creditors, or members for that matter, must do no worse off under the restructuring plan than they would in the event of that so-called relevant alternative, i.e. they have to do better under the plan than they would in an insolvency process. And that one, I think, is going to be the one which will come under the most scrutiny from the courts. In close-run cases, it may well mean that there will have to be valuation evidence put before the court as to whether the creditors do better in the event of the plan. And it's going to be interesting to see how that one plays out in practice. There is one further condition that has to be met for all plans, whether or not including the cross-class cram-down, and that is the so-called financial condition. So the company has to have encountered or be likely to encounter financial difficulties that are affecting its ability to carry on business, and the plan, the compromise or arrangement, must be proposed as a way of trying to eliminate, reduce, prevent, or mitigate the effect of those financial difficulties. So that sets the restructuring plan very much as a restructuring tool. And the reason for including those conditions was the government didn't want this to be another way of doing a takeover or merger, for example. This is part of the restructuring toolbox. However, it's very important to say that that does not necessarily make it an insolvency proceeding. This legislation is under the companies legislation. It will be used by distressed companies, but the companies does not have to be unable to pay its debts. And it's already been held that this is not an insolvency proceeding for pensions purposes. So, for example, it will not trigger the pension scheme going into the PPF. And there may be other reasons why deciding whether this is an insolvency proceeding or not will become apparent, will become necessary, including foreign recognition, which I'll come to in just a second. The restructuring plan, just like the scheme, can be used for English companies, but it can also be used for foreign companies so long as there is sufficient connection with the UK. And it is understood that the courts will apply the same test as they have the schemes as to whether there is sufficient connection. So, for example, if there is English law governed contracts, then that will be sufficient for the scheme, for the court to accept jurisdiction in relation to the plan. And the process is very, very similar to a scheme. So there are two court hearings. The first, the convening hearing, where the court will grant permission to the company to convene the relevant meetings of creditors or members. And then at the end of the process, a sanction hearing where the court has discretion to sanction the plan and will only do so if it considers that it is fair. Now, what will count as fairness and what factors the court will take into account when exercising that discretion, particularly if the plan uses cross-class cram-down, is not yet clear. And Mr. Justice Snowden, who many of you will know, a fantastic judge in the UK, summed it up beautifully in a recent seminar for the ILA, where he said that this is a bit like a child being given a new toy for Christmas, a shiny new toy, only to find that there are no instructions in the box. And so, that was specifically in the context of cross-class cram-down. It is not clear in the legislation what factors the court will take into account when deciding when to exercise its discretion in that regard. Having said that, I am absolutely certain that the judges will deal with that issue and will come up with the jurisprudence, possibly looking to the US jurisprudence in relation to how cross-class cram-down works in the US. So just finally on the restructuring plan, what about recognition? And I mentioned the fact that you can use the plan in relation to a foreign company, but will it be recognised in the place of incorporation or, just as importantly, other jurisdictions where the creditors are located? Well, just on that, it is worth saying that the restructuring plan is not an insolvency proceeding for the purposes of the European insolvency regulation. And in light of Brexit, it wasn't even worth trying to get the plan listed in the annexes. I can't imagine that the Commission would have had much time for any such request. So certainly we will not get recognition under the European insolvency regulation, which of course will fall away in the end of December in any event. More interestingly, though, is the question of whether it would be an insolvency proceeding for the purposes of the UNCITRAL model law, which obviously a number of jurisdictions have adopted. And I think the answer to that is yes, if the implementing state has done like the same as what the US have done in relation to Chapter 15 and extended those proceedings to proceedings relating to the adjustment of.
I think we have a frozen internet connection there. Jenny? I think she's been frozen out for a minute. Philip, are you there?
Yep. Can you hear me?
Yes, I can. That's great. I think Jenny was wrapping up in any event, so perhaps now I'll hand over to you and we can return to her at the end.
Yes, I mean, I'm very happy to act as a reserve because I found her stuff very interesting, so I hope she will come back at some early date. Anyway, I'll fill the gap if that's okay. Now, what I'm going to do, folks, is to discuss the neutering of what are called ipso facto termination clauses on an insolvency. And I must say I have a sort of angle on these clauses, a special angle. One is how is the legal system positioning itself in relation to other countries? Because a great many other countries already have this clause, which provides basically that insolvency events and defaults are nullified on insolvency, and then there's a number of carve-outs usually. So it's very frequent, internationally now. First introduced into mainstream insolvency law in 1978 by the United States in the Bankruptcy Code, and then by France in 1985, in the redressement judiciaire. So it's been around for quite a long time. Now, the second angle I have on this is that for me, as a sort of business, Jenny, do you want to carry on?
Luckily, I was very, very nearly finished, Philip. So,
okay.
So with apologies to everyone for the connection issues, I will just finish by saying that I think our restructuring plan will be recognised under Chapter 15 because of the adjustment of debt wording. And I'm also hopeful that we will be recognised under Rome 1 because the restructuring plan, to the extent the restructuring plan deals with an English law contract and is seen as a process for adjusting the law of the English law contract. And of
Jenny, we've lost your audio.
Oh dear. Can you hear me? Can you hear me, Joanna?
Yes, I can. I think we should probably hand over to Philip now. Thank you for that.
Right.
That was very interesting. I think we're very lucky to get through to your recognition points, and thank you for clearing that up for us. Okay, Philip, you were...
Okay, I think I was in mid-sentence, but I can't quite remember. I think I was saying that insolvency law I use as one of the real tests of the credentials of a legal civilization in the context of its commercial and business and financial law. And that's because it's the point at which the law has to decide, there's not enough to go around. And so there are winners and losers, there's a victor and a victim. And it's quite savage in the choices which are made. And it raises enormous passions. And so people do tend to take sides because of that, which is perfectly understandable. And so it's quite a good temperature taker. It's a litmus test of what's happening in world jurisdiction. So that's my sort of angle on it. In a moment, I'll come round to trying to explain what I see is the lineup of the world on this. But first of all, what I'd like to do is to explain what this particular act says. Now, it's got three main new freezes. The first one is that if a company becomes insolvent, then any clause which provides for that a contract for the supply of goods or services to the company can be terminated is ineffective. So the termination clause is ineffective if it is because of the opening of the insolvency proceedings, which is all insolvency proceedings, liquidation, administration, moratorium, whatever. It applies to all of them. And it only applies to contracts for the supply of goods and services to the debtor by a supplier. So it's an event of default whereby the insolvency event of default is void in those circumstances, but not any other event of default. So a payment default would nevertheless give rise to a termination right. Now, the second stay is a provision that if there has been an event of default or a reason for terminating the contract prior to the insolvency, then the supplier must have exercised that right by the time the insolvency opens. And that applies to any event of default. And I think the purpose of that is to prevent people from using events of default to strengthen their hold-out position on the insolvency. And then thirdly, there's an exclusion which specifically prevents suppliers from conditioning the supply of their goods or services on prior payments being made, and that's to reduce the bargaining power of creditors of suppliers. Now, this only applies to contracts for the supply of goods and services, so it obviously doesn't apply to land. And we'll see in a moment there's a big carve out for the financial sector, but obviously also but it's unclear whether it applies, for example, to intellectual property licenses. I doubt it myself, but I suppose it could. Now, as I mentioned, there's some very wide exclusions, basically to take the whole of the financial sector completely out of this. So it's sort of the supply of strawberries to Tesco, if you like, which are caught by this provision. And there are three main sets of these exclusions. The first is that all of the main regulated institutions, whether they're a supplier or whether they are a debtor, are outside this altogether. So that's banks, investment banks, insurance companies, collective investment schemes, dealers in investments, custodians, alternative investment funds, and so on. They're completely outside this. And there's also a foreign activity exemption, which means the foreign equivalents are excluded. You have to look at the particular definition, but I think they are very wide. So that's the first exclusion. The second exclusion are contracts for the provision of financial services. And really that's enormously wide because it includes lending, factoring, financing commercial transactions, giving guarantees, securities contracts, derivatives, financial commodities contracts, interbank deposits of 3 months or less, master agreements, securities financing, repos, capital markets, investments, so on. Very, very wide. And then thirdly, there are some specific exceptions which one might expect for financial collateral, for settlement finality because of the systemic risks, and also for set-off and netting arrangements. So although most set-off and netting for derivatives are specifically included, there is this overall blanket exception for set-off and netting arrangements generally. And by that, I think it means an exclusion for contractual rights to set and net off. Okay, so basically that's what the three stays are. Now, I was just going to make a few comments on this before looking at the international spread. The first is, why does the legislator do this? And why do so many insolvency statutes also want this? The first reason is the objective of increasing the assets of a debtor so that the business can be sold as a whole, keeping the whole business together so that if you can do it, a nice quick pre-pack, all of the company's assets, including its contracts, can be sold off in one shot to a new co or to somebody else who steps in. And that's all part of the rescue philosophy, which has been with us now for 50 years or so. The second reason is to prevent a supplier from cancelling a contract which is in the money, because you could say that technically that's a deprivation of an asset. It's like walking into the company and helping yourself to the sofa, you know. All of these assets are to be available to all creditors. So that's the second reason. And the third reason, I think, is to prevent hold-up creditors. It seems to have been thought that a contracting party for the supply of goods and services could have a hold-out power. And that hold-out power has definitely been shown in relation to essential supplies like gas, electricity, and water and so on, which have been outside, which have been restricted in any event now for many years. So those are the reasons. And so then on the other side, we have to look at some possible disadvantages, because one feature of the law, which is a sort of a system of justice and fairness and morality, whatever you like to call it, there's always pros and cons. And this area is particularly difficult because those pros and cons compete intensely, and it's really hard to make up one's mind about what the balance should be. Anyway, I'll say what I think are the disadvantages, and then you, the audience, can decide yourselves what you think, is the winner in this contest. And that's really what, legislatures are supposed to do. So first of all, if you have a scheme like this, the debtor can cherry pick contracts. That means the debtor can cancel or refuse to comply with ones which are not profitable, and to insist on the maintenance of those which are profitable. So the debtor gets to pick and choose at the expense of one particular creditor. That only applies if there are a whole string of contracts. So you could say that the debtor is in a better position than the counterparty who's insolvent, because the counterparty doesn't have that option to get rid of a contract and not pay for them because the counterparty is solvent. So, and that's actually that idea of paying but not paying, wanting to be paid but not paying, is at the heart of set-off. So it's part of that argument. And frankly, that's a discussion which has been going on for about 5 centuries, particularly in relation to set-off. And this is just an application of that principle, somebody who wants to be paid but doesn't pay. So now the next thing is actually about set-off and netting, which has always been very much quite an important policy choice in English insolvency law, the backing of set-off and netting, which unquestionably gives a super priority to the creditor who has got this right, because the creditor gets paid when otherwise the creditor won't. Now, set-off and netting are exempted in this legislation, and so the only problem which I might have with that is that now it's only a contract to set off, so far as I can see, which is taken out, and the old regime where you didn't really need a contract seems to have gone. And the second thing is more important to me because I try and avoid as much work as possible. I don't like reading too much, and I find it very hard to read all these complicated statutes. And it means that the present regime, that if somebody who's, say, in the UK or outside the UK wants to know what the position is on netting, he's got to read a 248-page act. Now, if you multiply that by 321 jurisdictions, you get a hell of a lot of reading. I mean, we are definitely in war and peace territory or something like that. So I think that internationally, it's this layering and the complication makes the law much more difficult for foreign traders, for example, to take on board. So effectively, you can chill deals simply because people haven't got time, to work it out. So I think that's a possible disadvantage. The third possible disadvantage is whether whether a creditor for goods or services outside the financial sector, and apart from supplies of electricity and so on, whether they are your original holdout creditor who is preventing a proper rescue deal. I think that is a question of whether, in practice, they do have this bullying power or not. And then I suppose one could say, does it sort of really matter? Is it disproportionate to interfere with the commercial fabric of contract? Contract is everywhere. Contract is king. It's everywhere. Do we really need to do this? Do the advantages outweigh the disadvantages? So I think those are the questions on that. Now, to me, on the Marmite issue, I have to say I'm not a big fan of this particular provision because I think it's inconsistent with English law. But I have to tell you, my friends, it's not inconsistent with what's happening in the rest of the world. And I'll try and summarize what I think is happening. I would say I haven't looked at all of these jurisdictions in great detail over the last few weeks or months or year. So things may have changed. And the ones I have looked at, I may just have completely misunderstood. So if we can take that as an apology in advance. Now, if we go round the world, the position is in North America, United States and Canada already have this provision. So North America have had this for quite a long time. If we now do move down to South America and the Caribbean, I don't think any of them have it, but there are a few isolated cases. Chile, I think, Barbados, Puerto Rico, maybe. I'm not sure about Brazil. I don't think they have this neutering at all, but I'm not too sure. When we get to Europe, Europe's already decided to go for it under the restructuring directive, so the whole lot are going to import this into their legal system, and a lot of them had it already. Spain, France, Belgium, Germany, and so on, they already had it. The position of Switzerland and Turkey, I'm not so sure. When I last looked, which was about 12 months ago, they did not have this. Jersey and certainly doesn't have it. Now, if we move over to the Middle East and North Africa, I don't think any of the jurisdictions in the region have it, not Israel, but actually the Saudis do. But I don't know whether they've actually implemented that particular position in their new legislation. Moving over to Africa, Africa is split. It's split into what were into a group of countries like the original English-based countries, which don't have this provision: Nigeria, Kenya, Malawi, Ghana, and the French-based countries, which do have the whole of the 17 countries in what are called the OHADA group, have this provision because they inherited it from France and because they adopted a version of modern French business law a couple of decades ago. So Africa is half-half. When we get to South and East Asia, the position seems to be they're not so keen on this. Now, I don't think that China has it, not Japan, not Indonesia, not Malaysia, not Vietnam, not Thailand, and I couldn't find it in the Indian Act. Maybe it's there, but I couldn't see it. But on the other hand, Singapore does have it, and so does Australia. New Zealand's got something like this, but it's quite modest. And funnily enough, one country which now has imported this is Afghanistan, who've had an insolvency law since 2018, and they adopted this provision. So that just leaves the former USSR countries. Russia, Ukraine, I'm not sure, unless it's happened recently. I couldn't find it in their laws. And I don't think any of the other Central Asian countries, some of them, frankly, are just not really interested in insolvency law. Maybe they've got a point, except Kazakhstan. So that's the world where, you know, if you took the jurisdictions of the world, which are that, which fall into these groups of Napoleonic or English common law or Germanic law and so on, all of those groups are now cut across. This cuts across all of those. And we have a much more complicated position in the world. So really, my friends, that's it. That's all I have to say. I hope you found something useful in that. Thank you very much.
Thank you, Philip. And again, thank you to Jenny earlier. I am now we're barreling down into the last quarter of an hour of our time together. I'm now going to try and do this technically challenging thing of looking for Q&A. I don't see any as yet. So unless Camilla sends me one that I have overlooked, I am going to ask you a question myself, and to either of you, which provisions do you think in this act will be of most interest to our US counterparties? I say that as if I have US counterparties. Jenny.
I suspect it will be the restructuring plan that creates the most interest. And of course, you know, from a Chapter 11 perspective, cross-class cram down is nothing new. Although I do understand from talking to my US colleagues that, you know, even though Chapter 11 does have that feature, you try as hard as possible not to use it unless you really have to avoid some of the valuation disputes that it can lead to. So I think the restructuring plan will be of most interest to our sort of US counterparts. I think the idea that you can use a UK process in relation to a foreign company to deal with English law debt, I mean, some people find that quite hard. Other people find that absolutely quite understandable. I mean, it's an English law contract, so why wouldn't you use an English process to vary or discharge an English law debt? But certainly, I know that, you know, there are bond prospectuses and other documents where people are having to consider whether to include risk factors in relation to the restructuring plan. And people are saying, well, hang on a second, if I have an overseas issuer, why do I have to include this in my risk factors? To which I would say, well, because it's English law debt, and, you know, the position is no different with the Chapter 11. And also, when other European jurisdictions come to implement the restructuring directive, I think we're going to see cross-class cram down across Europe to quite a great extent as well.
Thank you, Jenny. Now I see, before I turn to you, Philip, that we have a question from Greg Mitchell, who is clearly suffering from reduced sports access during the lockdown, because he asks, having regard to the so-called football creditors rule, what effect will the new act have upon insolvent football clubs? Now, I'm not aware that that's a specialist area for either of you, but I could be wrong. Do either of you have a view on how this act will affect football clubs?
Well, I have to profess to not being a football expert, either as participator or as restructurer, but I am aware of the so-called football rule, which has made it quite difficult, I think, to do company voluntary arrangements in relation to football clubs. And it is not entirely clear to me that the plan would fare any better. I mean, I suppose you could try to put the the sort of creditors into separate classes and then use the cross-class cram down, but I don't know whether that is going to be successful. Perhaps it will depend on whether the judge you get is a football fan or not. Interesting question, and one I think I would have to think about.
Well, I think my response to that is a matter of great regret at what's happened to these football clubs, because I think it is the most beautiful game. But I think they would be astounded at the. Of course, I'm astounded at the intricacy of their playing football. I think they would be astounded at our intricacy in fashioning financial democracies with all these classes of different creditors. I think it'd be absolutely amazing and say, well, why can't we just have a democracy? So anyway, it's all very regrettable.
Thank you. Now I'm going to check for. Yes, I think we don't yet have any further questions. Oh, we do. I was going to ask you one of my own ignorant ones, but we're going to have an erudite one from Helen Coverdale, who asks, do you think in practice the moratorium will be used as a standalone procedure or as a gateway to another formula procedure? And that, if I may say so, is an excellent question.
It is indeed.
Philip, you're on my screen. Do you want to respond to that, or would you like me to pass?
I think that's really Jenny's department, to be honest.
Yeah. Okay. In that case, I will pass that over to Jenny.
Well, Helen, that is a very, very good question, because, of course, the whole purpose of the moratorium is to achieve a rescue, and the monitor has to file a statement to the effect that the company is capable of rescue. Now, it may well be that just giving the company a bit of breathing space in the COVID environment, just giving it a little bit of breathing space from paying its moratorium debts will be enough. But I suspect in the vast majority of cases, you will need the moratorium as a gateway or something like a company voluntary arrangement or restructuring plan. And of course, it is possible to do the plan or the company voluntary arrangement or the scheme of arrangement for that matter, within the context of the plan, of the moratorium. So you can use the moratorium to create the stay on creditor action, and then you can use that stay while you put together your proposals for a CVA, a scheme, or a plan. And so I think if the moratorium is going to be used, I would see it as a wrapper or a gateway to one of those processes.
Lovely, thank you. Now, I think that's it for the moment for questions from the audience. So I am just going to ask very briefly if my ignorant question, because I've long wanted to know the answer, which is how you see this slotting in against schemes of arrangement. We have another question, but would you just say a word about that, Jenny?
Yeah,
the constituency of each as things move forward, or whether we're just going to see a withering of schemes?
It was a really interesting question, because I had assumed that everybody would start using the plan and the scheme would sort of wither and die, but quite the opposite. I think when you look at the cases that are being filed at the moment, and the English court has a scheme hearing every single day in August. It is just absolutely amazing. And it is the scheme that is still being used. And I think the reason for that is that the scheme is tried and tested. People know where they are with the scheme. The judges know where they are with the scheme. And the suggestion is, well, why would you use something new and something that hasn't yet been tested if you can achieve everything you want to achieve with the existing scheme? So I think, in short, my answer, Joanna, is if you want to use cross-class cram down, then you may well use the plan. But if you can do everything that you want to do through the scheme, then there is quite a temptation to use something that is tried and tested.
Lovely, thank you. Now, we might have time for this one question before I wrap up. This is Don Diamiti, who asks, how significant a role do you foresee the monitor playing? That's a good question. Extensive and expensive. Philip, do you have a view on monitors?
Not really, but I think Jenny might have a view. I mean, the directors are left in charge, and the monitors, like so many of these supervising administrative officials, they have a monitoring role whereby they have to approve important decisions. But otherwise, the directors, it's sort of a midway position between director, debtor in possession, and having an insolvency administrator who runs the show.
It's a really good question. Well. Yeah. No, it is a good question, because I think, one thing that we, before the Act became law, we were trying to see what we could do with the existing tools. And one thing we said, well, you can use administration in a pretty light touch way. So you can, on day one, an administrator can delegate certain powers and duties to the directors. It's not a delegation as such, because it's allowing those directors to continue with their existing duties, and the administrator can play a more sort of monitoring role. And so we wondered whether you could actually use the existing administration regime to do that. But the concern was that administration is not traditionally, at any rate, seen as a debtor in possession procedure. So the idea of the moratorium was to introduce exactly that, to make it lower cost, directors staying in control, exercising the day-to-day management functions, but with the monitor playing that sort of light touch supervisory role. Having said that, the monitor does have duties and responsibilities, and can even be criminally liable if he or she gets things wrong. And I suspect that the firms of accountants who take on these roles are going to want to be quite careful about giving the statements that the company is capable of rescue, and making sure that they are exercising their powers properly and bringing the moratorium to an end if it's not being used properly. And that, unfortunately, will add to the expense of the process. And I think that is one of the reasons why I am yet to be convinced that the moratorium is actually going to be as successful as I think the UK government would like, for exactly those kinds of reasons.
Thank you. Well, that brings us very neatly to our time allocation. It's 2 minutes to the hour. And so it only remains for me to thank both our distinguished and expert panelists for their hugely interesting and informative contributions today, and also to thank you, the audience, for making time to join us.